The question is as moved by Mr. Leong Man Wai. Mr. Vikram Nair.
Mr. Speaker, congratulations on your appointment as well. The position of Speaker exists in almost all modern parliamentary systems. The Speaker is generally a member of the House that is selected by fellow members with a majority of the vote. Now, Singapore's constitution does not require the Speaker to be a member of Parliament, but the general practice has been for the Speaker to be an elected member. Now, in most countries, the result of these two practices, namely the Speaker being an MP first, and second, the Speaker being elected by the majority of the House, is often that the Speaker is an MP from the ruling party. There are times when non-ruling party MPs get elected as Speaker, and in Singapore's case, when non-MPs also get elected as Speakers, but this is the exception rather than the rule. Now, the PSP's proposal does not seem to be suggesting we do away with this completely, but just seems to suggest with certain parameters around which the person should be selected, namely that the individual should not have been a part of the core leadership team of the ruling party. Now, I do not think there is a need for this additional limitation, and I will explain this in my speech. The most important point is the Speaker has to command the support of the majority in Parliament. And why is this important? The Speaker has the duty to preside over elected representatives in the chamber, and he must in turn have their mandate to do so. Otherwise, you'll have the anomalous situation of an unelected person potentially controlling the proceedings of the elected officials. And I think while my colleague, Mr. Leong, highlighted some similarities between judges, the role of a judge and the role of a speaker, there are also some important differences. And one of the most important differences is that a judge makes decisions on the facts before them, and their decision binds all parties on those facts. The Speaker, on the other hand, presides over parliamentary proceedings. And while the Speaker may make decisions on procedural issues, the substantive decisions are made by the legislative chamber itself. Bills can only be passed by elected representatives. The Speaker does not have the power to force a bill through. Now, before Singapore's independence, when we had a legislative assembly under British rule, the first Speaker, Sir George Ohlers, was appointed by the Governor-General, who was the representative of the Crown, and this was in 1955. Since independence, though, Singapore, like the UK and all other Commonwealth countries, had its own parliament, and the Speaker was the one who was voted in by the majority of legislators in Parliament. As a matter of practice, the Speaker was nominated by the Prime Minister, since the Prime Minister is the individual who commands the support of the majority in the House. Now, the Speaker in Singapore does not have to be from the ruling party, but usually is. And I think after Sir George Ohlers, our next Speaker was Mr. E.W. Barker in 1963, and he was also a very successful lawyer. But he was a member of the ruling party. The next speakers after him, Mr. A.P. Raja and Mr. Pranch Coomaraswamy, were not members of the ruling party, but they were nominated by the Prime Minister and endorsed by the majority of the House. Following that, though, from 1970 onwards, we had three of our longest-serving speakers, Mr. Yeoh Ghim Seng, Mr. Tan Soo Khoon, and Mr. Abdullah Tarmuji. And the three of them took us all the way from 1970 to 2011. All three were members of the PAP. In Mr. Abdullah Tarmuji's case, he was a member of the cabinet, so a part of the core leadership team before becoming a speaker. But they were appointed the same way as their predecessors, namely nominated by the Prime Minister and elected by the House. Now, the fact that the Speaker is from the ruling party is not something that should take away from their discharge of their duties. The Speaker is still required to discharge their duties independently and impartially. The motion talks about Parliament being a fair arena. However, the fairness of Parliament is not just dependent on the individual who is the Speaker. The Speaker himself, like all members, is bound by Parliament's standing orders, as well as the Parliament Privileges, Immunities and Powers Act. Parliament's standing orders give members who wish to speak a wide range of opportunities to do so. They may file parliamentary questions for written or oral answer, which ministers will have to address publicly. They may speak on any bills put forward by the government, meaning they have a say on any and every piece of legislation that passes this House. They may file adjournment motions if they need more time to speak on specific issue, and again, the relevant ministry will be required to address the issues raised. Finally, if they wish to speak at length on a topic, they may file a motion, which Mr. Leong is doing today. Now, the Parliament Privileges, Immunities and Powers Act sets out additional protections for members of Parliament, including freedom of speech, such that anything that is said in Parliament is generally protected from proceedings in court or any other forum other than Parliament itself, which is why Parliament is the first port of call if members were to breach the standing orders. Now, all these matters provided for in Parliament standing orders give every member, whether from the ruling party or the opposition, the opportunity to raise and discuss matters they feel are important. In keeping Parliament a fair arena, it is therefore also important for all members to respect and comply with these rules. The substance of keeping Parliament a fair arena is, I would respectfully say, largely captured by these rules and the law. The Speaker has the duty to ensure observance of the standing orders by members in parliamentary proceedings and must be independent and impartial in doing so. And if indeed there is any allegation that the Speaker has not acted independently and impartially in any decisions, these should be the subject of a specific motion. No such motion has been put forward. Our process also has its checks on the Speaker's conduct, should the Speaker fail to discharge his duties properly. The first is the Speaker's own party, if it feels the Speaker has not acted properly in any way. The second is Parliament itself, where members are free to raise any objections they may wish, or even file the necessary motion. Third, the ultimate check on a member of the legislature is the ballot box. As Parliament debates are public, every action that the Speaker may take is up for public scrutiny. If there's any allegation that he has been unfair or impartial in the discharge of his duties, that is something the voters may take into account, both against him and even the party he is from, if the party endorses that conduct. Now, I think Mr. Leong has made some references to the UK and the Speaker there. Now, I would say different countries may have different practices in selecting the Speaker. The UK has a practice of the Speaker resigning from his political party upon nomination and actually being dragged, supposedly unwillingly, from his chair to take the seat of the Speaker. And this is because of the history of the Speaker sometimes having to deliver uncomfortable news to the Crown and for which he may face the consequences. However, even though the Speaker may resign from his party upon nomination, it is clear that he still has the support of the party that commands the majority in Parliament, and in most cases was a former member of that party. That would suggest his personal beliefs are likely to be aligned with the party he was a member of. Notwithstanding that, in the discharge of his duties, he is expected to be independent and impartial. Now, there are other peculiarities in the UK's approach, including that the Speaker's seat is generally uncontested by other parties when he campaigns as speakers. He is thus likely to get re-elected unchallenged if campaigning as a Speaker. This means that unlike the Singapore system where people vote for all legislators, including the Speaker, in the UK, the Speaker would not be subject to a challenge at the ballot box. So his accountability in that sense is only to Parliament itself should the majority nominate him again. Whereas under our system, I've mentioned, the Speaker has three sets of checks: the party he's from, the Parliament itself, and third, the ballot box. Now, this is a different approach, but I do not think it is necessarily superior to the one we have. There are other Commonwealth countries, such as Australia, which have a system very similar to ours. There, the Speaker remains a member of the political party and will have to campaign for re-election like any other member. The Speaker needs to get the support from the majority in Parliament. In practice, most of the Speakers have been from the ruling party, although there too there are a few notable exceptions, just like in Singapore. Now, the Speaker in the Australian Parliament has often had to exercise a much firmer hand than the Speaker in Singapore on points of order and breaches of the standing orders in Parliament. Yet, despite the Speaker being from a political party and exercising these powers, nobody has seriously suggested the Australian Parliament is not a fair arena for debate. I therefore do not think that the fact the Speaker happens to be from a political party or from its leadership automatically means that he lacks independence in the performance of his duties as Speaker. Now, finally, I believe this obligation to keep Parliament a fair arena for all is not just for the Speaker, but also one which every member has a part in. It is important for members to respect the standing orders so that other members will also have opportunities to speak and raise the points they need to speak. It is thus important for all members to honour and comply with the obligations as set out in the standing orders, as well as the Parliament Privileges, Immunities and Powers Act. Against this backdrop, Mr. Speaker, with your permission, may I propose an amendment to the motion?
Can I have a copy of your amendment?
Yes.
The amendment is in order. Are copies available for other members?
Yes. If I may
Please
trouble the
move
clerk to
your
distribute.
amendments.
Just wait for members to get copies.
Yes, let's give it another minute.
Yes.
Yeah. So now you can move your amendment.
Thank you. Mr. Speaker, I beg to move the following amendments. In line 1, after the word commitment, to insert A. In line 2, to delete the words be independent and impartial, and to insert discharge his duties independently and impartially. And 3, at the end of line 2, to add and B, to uphold the standing orders of Parliament and the obligations under the Parliament Privileges and Immunities and Powers Act 1962. Now, these amendments have been marked up in the handout for members' reference. Now, I agree with the PSP that the Speaker must act independently in the discharge of his duties, and the First Amendment reflects this. This has been suggested so that the motion is not misinterpreted to mean that the Speaker cannot be from a political party in order to be independent. The amendment therefore focuses on the independence in the discharge of his duties, which is the standard speakers in all parliamentary systems are held to. The speakers in many Commonwealth parliamentary systems come from the ruling party, and that has never been a basis to say Parliament is not a fair arena for debate. The second part of the amendment is, I think, equally important. As I had explained earlier, many of the rules that ensure Parliament is a fair arena, including the rights and obligations that members have, are all actually in the standing orders and the Parliament Privileges, Immunities and Powers Act. Now, these are rules that every member should be committed to in our shared obligation to ensure Parliament is a fair arena. I therefore beg to move the motion as amended, Mr. Speaker. Thank you.
There are 3 amendments proposed by Mr. Vikram Nair to the motion. In line 1, after the word commitment, to insert section A. In line 2, to delete be independent and impartial, and to insert discharge his duties independently and impartially. And the third amendment is, at the end of line 2, to add and B, to uphold the standing orders of Parliament and the obligations under the Parliament, Privileges, Immunities and Powers Act 1962. It may be convenient that the debate on the original motion and on any other amendments moved by members be proceeded with simultaneously as a debate on a single question. Do I have honourable members' agreement to this? The question is the amendments as moved by Mr. Vikram Nair.